photos doing that? Okay. You know, in a case where the dispo is HOP, given the arguments I've given you in the Code of Federal Regulations, which has just come out, I think there is an argument to be made that you can still go forward on dispo. However, it's best practice to still follow up on ICWA notices. In those cases, perhaps a progress on ICWA is prudent and appropriate and no harm, no foul, because the child remains home with parent. However, then you are getting the information before the court for any future issue of if the child gets removed. So it's prudent to follow up on ICWA notices, even if the child is home with parent, if there is a real possibility that this child may be an Indian child, and that's a circumstance where courts may be doing the ICWA progress. But I have also seen it where courts are doing a suitable placement order and then ICWA progress. Still? Yeah. Well, no, I know that's the law, but I'm telling you, I've seen 3 courts do it before. So I was just curious whose courtrooms are doing it because it's a big problem. And what I would say to you in terms of, I know that the continuance hearing focused on us pushing the issue of getting hearings done within the time frames. And sorry, I'm kind of jumping all over the place today, but getting hearings done within the time frames. And what I would say to you is that it doesn't require the case to be put on 60 days for a dispo, past 60 days. That is not the requirement. The requirement is that you cannot find that a child is not an Indian child if there still exists some reason to know, and not all of the tribes have responded to notice within the 60 days. The solution to that problem, if we want to go forward on a dispo and we don't want to put it out, is you say, department, put on your case. You have to act like this is an Indian child for now. Get your expert. I'm going forward on dispo. I am objecting to a continuance. At this time, we have reason to know or believe this child is an Indian child. I'm going forward. The court may then continue on their own, but we should make our records. There's no requirement in ICWA that it has to be continued for those receipts and notices to be had. The actual code says that you proceed as the child is an Indian child unless and until you figure out the information that they're not. And the information that they're not is either every tribe responds earlier than the 60 days saying they are not, or the 60 days lapses and no tribe has responded that the child is an Indian child. Does that make sense? Okay. So I gave you a little page about reason to know. What is reason to know that an Indian child is Indian, maybe an Indian child? And that's what I was just trying to explain to you guys about how any biological parent, grandparent, or great-grandparent have been members of a tribe, or the domicile in an Indian community or reservation. Those are the questions that the judges are sometimes asking at detention. But even more so, California rules of court include the child or a person having interest in the child informs or otherwise provides information to the court suggesting the child is an Indian child. So that's where we have the situation where it's anyone with an interest in the child who can provide some information saying, you know what, like, I'm a friend of the family. It could be a non-related person. I'm a friend of the family, but they told me that this child is, Menominee Indian. So, and at that point, you've got to put that information down, or the court needs to order notices. And then the 25 CFR 23.107 is that you must treat the child as an Indian child until it's determined otherwise. And that's also California rules of court that I cited for you there. Inquiry may trigger notice. Gave you a couple of cases that sort of talk about the different circumstances where it does trigger, what really does trigger notice, what doesn't. Dwayne P., the statement was, by father, I may have Cherokee heritage. That triggered notice in Dwayne P. Because there was a suggestion that the child was an Indian child, and they went very Merriam-Webster in the opinion and put some synonyms into the opinion about synonyms for suggest, imply, hint, intimate, insinuate. So that case really didn't take that much. I may have Cherokee heritage was enough to trigger notice. However, Jonah D. states that vague, attenuated, and speculative information is not. In that case, when you have a paternal grandmother whose statement was that her grandmother told her about some Native American ancestry, but she didn't know any tribe. She didn't have any more information about it. She just knew that the grandmother knew that her grandmother told her that they might have Indian ancestry. That was too vague, attenuated, and speculative. So those are sort of your barometers. Work with that. Yes?
In my courtroom, my bench officer.
Where they respect you, don't shut them down.
I think I might have a passion in Navajo, and my dad has some information. I don't have my dad's number. So then our bench officer will say, "Have you ever lived on any Indian reservation or in your family?" And he'll be like, "No." I'm fighting no ICWA and don't send any notice.
Yeah, I saw your court do that the other day.
I always feel a little bad when I'm
See, and I think that's wrong. I think that's wrong, and we should be pushing back. I think it benefits our client, and we should be pushing back, unless you have some reason that you don't want to. What I would say to your judge at that point, to the bench officer,
is the money coming back up?
Respectfully, I believe that notice has been triggered in this case, and the department should have an obligation to send out the notices, even if it contains limited information, so the tribes can at least make a determination on their own if my client is a member or the child is a member of the tribe.
He actually makes it order that the department not to send out.
Yeah, I know. I'm telling you, there's a lot of courts who are doing these weird things, but we have to push back. I mean, and if you need to, take them up a couple of times. It was the #1 reversal on appeal. So, I mean, and most of the time, frankly, it's really funny because the department just concedes it. So if you do the appeals and the department keeps conceding, the judges are going to have to get on board at some point. But usually if the parent can assert a tribe name, that's going to be enough to trigger notice. And I gave you Alice M. also, where mom was just like, I think my kid is Navajo Apache. And that triggered notice. So it doesn't really take that much. And I know that everybody's like, notice is so onerous and it's such a burden and it's so hard. The 0 through 0 is so long and there's so much information and it delays things. I mean, honestly, I think the social workers need to train, but we can at least do our part to help out. And it's a big deal. So recently, some more cases, Cadence P came out saying that, so the juvenile court in that case inquired about the minor's Indian ancestry properly. And the department interviewed several relatives to obtain information. However, the court said that the Blackfeet claim was insufficiently supported.
Because he's got gone to them?
It was an uncle who said, I don't really know a whole lot about it, but I know that my mother told me that she was Blackfeet. And they also said that the Creek and Seminole ancestry was too remote because it traced to a great grandmother. The appellate court said, nope, reverse and remand. You don't get to determine how remote it is. It doesn't matter because, like I said, some tribes simply determine membership based on a lineal ancestry, tracing of the ancestry. Notice not required where foster care is not recommended. You have Alexis H. So this is that situation where it's a DISCO recommendation for home of parent. Do we require notice? Alexis H. says no. Jennifer A. says that placement of the child with a parent did not appear an ICWA violation because the issue of possible foster care placement was squarely before the juvenile court at disposition. Now, I will just say, difference in that case is that department in Jennifer A. was not recommending home of parent. After trial, the judge ordered home of parent. So it was a little bit different of a situation because it certainly was a more arguable issue. And then, as Ms. Berger brought up earlier, I just want you to note the potential problem that happens if even you follow the Alexis H, where original dispo, children remain with a parent. You could end up with the in re BH problem 2015 case.
I thought she was talking about high risk. I was like,
Removal.
oh, because she lives in Mexico.
Nobody redid notices, nobody redid an inquiry. It proceeded all the way to TPR 2 years later, and 2 years later it was a reversal. So 2 years of these children being out of their parents' care, in a foster home, experiencing that disattachment from them, and that's certainly I think a harmful error to our clients. So just be aware that even if the court says I'm not requiring at the original dispo because the child is home with parent, I do think that's maybe an appropriate situation for the why don't we just follow up just in case ICWA progress, or keep a note in your file somewhere that, hey, flag it as a potential ICWA case in case there is any subsequent removal. You do need to raise that issue. Checking for notice. So, like I said, this is where issue is not waived. Tribe always maintains the right, but how will they ever know? And why is it important? Tribal sovereignty. Been through that pretty exclusively. So the ICWA 030 form, that's the written notice form. I gave everybody a copy of that, I think, in your materials. About 10 pages. It is to be completed by the social worker. I know a lot of judges are ordering us to do it. California rules of court say it is to be completed by the social worker. The form itself says to be completed by the social worker. It is best practice to help the social worker complete that form if you can, if you have time, to go over it with your client. I just was doing a TPR reversal limited remand on an ICWA issue. Department filled out this what looked to me to be a very thorough ICWA 030. Had interviews with a bunch of relatives, a lot of information, but there was some missing. So I went out to my client, I went through it line by line with her, and I said, do you know that, like, there were some grandparents' names missing, that she had names for them. Like, they said that nobody had the information. It turns out grandma didn't have the information, but mom had the information because she has an Ancestry.com account. Good for her. It's important to go over the details of your client, and especially, I think we need to be very aware. I've been noticing that, like, a lot of attorneys maybe don't know what to do when a case is on a limited remand, reversal of TPR, and you're like, oh, okay, I'm reappointed to check notice, but what am I checking? That's when it's really important to go over the details, because I think you are going to get to a point at that stage of the proceedings where if notice is checked and done, and and you didn't go over it with your client, and I didn't go over it and provide the names of these relatives that should have been on this form, then the notices would be found to be proper. She could go ahead and appeal the case, but I didn't present any additional information to the court, so those notices are going to be proper, and at that point I will have waived any defect for my client because we didn't present the information to the court to know about what the defects in notice were. So on a limited reversal, I'd say that's the most important time to go over the 030 very detailed with your client.
And for the lazy people like me, what's the rule of court that says the social worker has to do it?
5.481.
Thank you.
I read the report.
And I agree the social worker should do it, and I am also that way, and I would be pushing courts to order the workers to sit down with our clients and actually do it, because what happened in this case where I found out that they didn't have names for my clients, like great-great-grandmother and stuff like that, was she said they called her over the phone, they talked over the phone, and they said, so,
no, I understand.
who do you know who might have Indian ancestry? Like, how is she supposed to know what the
she's not getting her visits, and I said,
I went through some of the stuff, and I'm like, oh, do you know your grandmother's date of birth? She's like, oh, yeah, I do. They didn't ask for that. And she didn't, and the county's argument was, well, she didn't provide it.
Really what it sounded like to me is
how is she supposed to know if you didn't
once
ask
we
her
started
the
talking
question?
about it,
She didn't name her grandmother, and if you don't say what's her date of birth, our clients don't know all the information they're supposed to provide. So I think the department should be obligated to sit down and go over the actual individual forms of them. Tribe has exclusive right to determine membership. Sometimes that can change. By the way, there is a case where the membership was revoked from the family, and case became a non-ICWA case in the middle of what was always an ICWA case. So things can change. It's up to the tribe 100%. Now we're talking about timelines. So timelines, if there's reason to know that the child is an Indian child, I told you all those things that suggest there's reason to know. So if there's notice pending, there is reason to know that a child is an Indian child. That's a good way to think about it. No hearing may proceed until at least 10 days after the parent, custodian, Indian custodian, and the tribe/BIA receive the notice. So please, please, please accept the detention hearing. Please, please, please check the green cards. This is receipt. It is not when notice is sent out. There needs to be a signed receipt with a date on it for when they received it, and the hearing cannot proceed until at least 10 days. If the parent or tribe requests it, a continuance of up to 20 days must be granted. So it's a mandatory continuance that you have in possible ICWA cases where notice is pending. You have a mandatory continuance of up to 20 days. So think about that. I mean, that can benefit us in a lot of cases where it doesn't even turn out to be an ICWA case, but you need a continuance to develop some information for juris or something like that. Notices are pending. It's a possible ICWA case. You can have a 20-day continuance, up to a 20-day continuance. Now, this is the part I was telling you all about earlier, California Rule Court 5.482 D2 and 3, the court is not required to delay proceedings for a response. So that is never a requirement. That when courts are always like, oh, it hasn't been 60 days, let's just put it out. Sometimes we do that because it benefits our clients, but that is not a requirement. If you are prepared and you think it should be a home of parents or something like that, push them. And apply all substantive provisions so long as there is reason to know. So that means the requirement for an Indian expert. That means the requirement for active efforts. That means the requirement for relative placement preferences. This is a great way to push our placement with relatives early on if it's a case where ICWA notice is pending. And just be aware that there's an ongoing duty to send updated notices to relevant tribes when additional information is received. So at any point in the case, if your client mentions to the social worker or you or anyone that like, oh, by the way, like I got back in touch with my mom and got some information about notices should be resent out. And the case it doesn't apply retroactively, so it's not as if at that point with the new information, your client's kid is suitably placed, it turns out they're an Indian child, that you get to go back to dispo. It applies prospectively, but notices should be sent out anytime there's new information. And I'm going to skip to, I put a lot of information here that I didn't intend to go over with you guys in great detail, just so you have the information. A lot of this stuff is information that would apply more to a case that actually turns out to be an ICWA case. Tribes always have the automatic right to intervene in the exercise of
what about this? So when are the visits scheduled?
For us, I would like to focus on placement preferences. So any out-of-home placement, you really need to be pushing this, and you should push it hard, especially with the new RFA procedures. I think if you have a case where it's possibly an ICWA case, push your placement preferences early as an emergency placement and let them deal with what they're going to deal with moving forward. If the tribe has an approved home study for a family or an approved home assessment, it is satisfied. That is independent of the RFA requirements. It does not apply to tribally approved homes. So if you can get a child placed with a relative, and then that home ends up getting approved by the tribe, great. If not, at least it's an emergency placement, and maybe it's putting a fire under their butt to work on what they need to do to make it an approved placement. It is always a preference for the member of the child's extended family. This can be de facto parents, but more often it is defined by the tribe's law or custom. Look to the tribe or look to very immediate families. Good cause to deviate from the placement.
Well, is the dad doing anything? Is he doing services?
Whenever a child in a case that may be an Indian case is placed in foster care, you should be pushing the court to set a good cause hearing, because That means if you think that that child may be an Indian child, that they have, whoever is choosing to place this child outside of the preferred placements preferences, so outside of relative homes, has the burden of proving by clear and convincing evidence that placement.
All right. Well, I'm probably I'm gonna call her and make sure that she knows the visits are gonna be every Wednesday at 3. And then she's been in the county for a couple weeks, 3 weeks or something. So probably before the 6-month review, I might file
sometimes at TFR,
388 to try and
I want
get the
everybody to be
denial
aware, like if you
reunification
have an
to
ICWA case and
change.
it goes to TFR, at that moment
You
at
know,
TFR,
that
you
was
should
basic. I was hoping
ask
Dad
for the
would
good
put
cause
something
hearing. Do
that
not
would
wait
help
any longer,
not doing shit.
because you certainly do not want to open the door for, if anything can be said from the Save Lexi saga, it's how much I learned from the mistake that occurred in that case. It was the court delayed the setting of a good cause proceeding, allowed these foster parents to get de facto status, and then it turned into a mess. If you're setting the good cause hearing concurrently with the TFR hearing, then you can avoid that situation potentially, or at least it forces them to try and get their de facto standing during FR. And we can make our arguments at that point. But relatives are number one, and it is not good cause to deviate because the child is bonded. It is not, that's not alone good cause to deviate. It is not good cause to deviate because of the status of the child. Are essentially extraordinary needs of the child. Like say the placement with relatives is going to be in a reservation that's very remote, doesn't have access to the medical care that this child needs. That is extraordinary physical or emotional. It is not, well, this child is just very attached to the family, or
I'll probably
needs therapy. I mean, if therapy can be put in place, therapy can be put in place anywhere. Placement preferences, I think, like I said, Holyfield, number one issue in ICWA cases. Your standards at disposition and termination of parental rights are heightened burdens. It is still at disposition, clear and convincing evidence. However, it does require testimony of a qualified expert witness that the custody is likely to result in serious emotional or physical damage to the child. And like any dependency case, there must be a causal relationship, okay? So the simple existence of substance abuse, non-conforming social behavior, crowded or inadequate housing, those sorts of things are not alone sufficient. That's your standard dependency argument in any case, but don't forget it. Termination of parental rights is beyond a reasonable doubt. I think we don't take this, if you have any case that gets this hard, sometimes we don't take the beyond a reasonable doubt standard seriously enough. That's a pretty darn strict standard. You have a question?
I mean, is there any way we can get her with a term therapist right now, even though she doesn't have
separate and apart from the expert testimony and the disposition hearing? Are they two separate things, or
yes.
They can be the same thing?
Well, they are two separate things. The tribe, oftentimes the expert that's submitted for a disposition hearing, in my experience, will be a social worker from the tribe or someone affiliated with the tribe, and they may want to speak as to the good cause issue, because sometimes the tribe thinks that there is good cause to deviate. Like maybe the expert may want to speak on the issue of good cause to deviate, but they are two separate issues. Your disposition is separate, and you do not require an expert witness for a good cause hearing. You require it for a dispo hearing.
But if the recommendation at disposition is suitable placement with a non-relative, does that then trigger the need for a good cause hearing?
I would ask for one, yes. I would. Anytime that there's a placement outside of the preferred placement preferences, I think it triggers a good cause hearing. I think that it'd be interesting to see how the courts want to do it. You might want to do the dispo first to see if the kid goes home.
I know.
But sometimes they'll combine them. I've not had a case with that exact situation, so, but I think they could be combined. And then your qualified expert witness.
No, that's what I told her.
Oh, what should an expert know? What should they do? Courts may be strict on you asking questions of these people, but you're entitled to ask questions, and the testimony has to be taken orally unless there's a stipulation in writing. So unless everybody stipulates to receive their letter into evidence, you need to take testimony orally. And Push them. Did you talk to the parent? Do you know what mom's doing? Do you know what her programs are? Have you seen her with her child? Do you know her relationship with her child? They may be very knowledgeable in their culture and tribal community, but maybe they don't have normal expert information you would expect on any regular case. Expert information pertaining to this particular case. So push them on that. And then active efforts. Does anybody have questions about active efforts? Active efforts, I gave you the handout because there's just so much that has come with the new federal regulations for active efforts. There's a big list of things that may constitute active efforts. I gave you the, I think it's like a 1 or 2 page fact sheet that talks about those. That applies from the very beginning that you know a child is an Indian child. Push the active efforts at detention.
But is there anything that must be done to constitute active efforts?
Well,
or is it just a bunch of stuff that may be active efforts?
No, I mean there's active efforts must be not, they can't be passive efforts. So active efforts have to include, forgot the handout and I'm blanking on the strict wording of the language, but there's nothing that say to you like active efforts means that they have to give them a cell phone. Active efforts means that they have to, active efforts means that they have to walk them through what needs to be done in order to get their children back, but they must reach out to culturally appropriate resources, reach out to any services that may be available through their tribe or through UAII, which is a United American Indian Involvement, Los Angeles-based program. They must do more than just give them a packet of referrals. Yes. Right, so that's always been part of the California Rules of Court. Are you talking about Abigail A? Yeah, so the Rules of Court have always said that that they must, if a child is eligible, that they're supposed to assist with enrolling them. What Abigail A changed is that that the Rules of Court of California used to say that a child who is eligible to be a member of a tribe, but is not a member of a tribe yet, and their parent they're not an Indian child, basically. The child doesn't qualify as an Indian child, but if you got them registered, they would be. The California Rural Court said you had to treat that child as an Indian child. Abigail A says, no, that's not the definition of an Indian child, but there is an ongoing effort in the case required to enroll that child eventually. So there is supposed to be efforts towards enrolling children into their tribes, which then would definitely trigger ICWA in a case. But sometimes that may happen after disposition. Have you had an experience with that in your courtroom? About the timing of the enrollment?
Not yet.
Not yet.
Yeah,
I know. I know. Any questions? I provided a lot of useful links on the last page, and like I said, I'll send it to you in electronic form. I know that was a lot of information, like so much information, and it's a lot to pack into an hour and a half. I tried to focus mostly on the notice, which is why I rushed through a lot of that more substantive stuff at the end, because every single one of you is going to face an ICWA notice case. So just be really aware of your notice. Thank you. Okay. Thank you.